the court a heads up, and then we will evaluate that if that comes up.
Your Honor, I am so sorry to interrupt, but I see that Mr. Sneed has just noted that you were muted.
You were, I didn't.
Oh. Well, then I'll have to repeat myself.
No,
Okay,
It was about 2 seconds of you saying media was your result.
sorry, the beginning or the end? So do I need to
It's the
repeat?
very beginning. I had it on pretty quick.
Okay. So you all have made your appearances. We're in, just to be clear, we're in case State of Nevada versus Meta Platforms, case 886110, pages 2 through 4. The court just had noted that there's a media request so that the media can do what they need to do consistent therewith. And if anybody has any concerns about anything that they need to say because of said media request, then they just need to let the court know. And then pursuant, as I noted in the actual signing of the media request form a while ago, then the court will address it and take everyone's position, including if any media outlet wishes to set forth their position. And it may be moot because realistically today, we're just gonna walk through to get you where you need to be on your special master appointment. So the only thing I show for today.
Yes, Your Honor, Michael Gayan for the state. One other quick housekeeping matter on a ProHawk application.
I signed one yesterday.
Yeah, there's one more. We filed it just 3 days ago on June 23rd. It's document 308 related to Matthew Bush. And Meta kindly and promptly filed a notice of non-opposition on the next day, June 24th. So the state asked to advance and grant that today, and we would submit an order. And then there's one other snafu related to this one that I wanted to bring to the court's attention. And I don't expect the court's had a chance to look at this. And so if the court wants to review the petition and not grant it in open court, I would understand that entirely. For Mr. Bush, my office inadvertently filed his ProHawk application in the Facebook case instead of the lead case originally, and it's document 21. So we didn't ask for a hearing, so it probably didn't even hit the court's radar. So we're asking, and it's footnote 1 in the application we filed, or motion we filed on the 23rd. We're just asking to strike document 21 in the Facebook case, case ending in 115, and advancing grant 308 in the lead case, which we refiled.
So let me go to Meta. Do you have any opposition to the court advancing it under EDCR 2.23? I'm not going to do it today in open court because I am going to need to re-look at it because the motion to associate was only filed on 6/23. And interestingly enough, the one that was filed in this case number 1 in the lead case 110 does say hearing requested, but the clerk's office has not had an opportunity yet to set it for hearing. And since I didn't receive anything that for preparation for a hearing, realistically, I was prepping all for this and all my other matters. So I can address the request to strike the duplicate of one filed in a subordinate case today because that's very administrative if there's no objection by Meta, but the actual request to admit to practice, the court does need to fully review under Supreme Court rules.
Thank you, Your Honor. Meta has no objection to their request to strike the other document, nor do we have an objection to advancing the hearing whenever that may be set for the underlying motion. And I guess you can rule by minute order on that whenever that is resolved.
Okay. So then we need to go into document 115. Did you find it by chance? You have the document number, or do I need to?
It's document ID number 21 in case ending 115.
Appreciate it. Thank you. Okay, so that document at the request of counsel will only be stricken because it was filed in a subordinate case rather than in the lead case. That's nothing to do with its actual merits of the underlying request. With regards to the underlying request to associate counsel Christopher Matthew Bush, the court's going to put it on its chambers calendar for tomorrow. since it's now been requested that you don't need a hearing and you're okay with it being on chambers, and since there's no objection from Meta for it being under EDCR 2.23. And I will look at it and you'll receive a minute order after the court's had an opportunity to review. Does that meet your needs, counsel for state of Nevada?
Yes, Your Honor. Thank you very much.
Does that meet your needs, counsels for Meta?
Yes, thank you, Your Honor.
Look, so that takes care of that issue. Let's get to your proposed special master document. And as you all know, because you were, I think most everyone was here last time, but I'll just give the quick refresher, is at the ending of the last hearing, which regarding some other issues, the court had noted that it had received the proposed stipulation, well, the stipulation proposed order for the special master applying to all three cases. And the court had some questions and some things that we needed to walk through. And I think you all told me at the very, my first question was whether or not you all were going to request, because since I didn't see it, an NRCP 16.1 F waiver issue, but I understand you're not, because I understand that you actually did do your early case conference and are in the process of doing a JCCR. Is that correct? Or can you please enlighten the court?
That's correct, Your Honor. The parties have held the ECC and I think one or two follow-up calls, and the JCCR's in the works. I believe it's due Monday, June 30th. So we'll be filing it and submitting it to the court then. I did confer with counsel before today's hearing. The parties are comfortable with, and I think believe it would be appropriate to designate the case complex, whether it's we note that in the JCCR and deal with it at a Rule 16 conference, or in this stipulation, we're fine either way, I think. But I think the designation would be appropriate for this case.
Meta agrees. We think the designation would be appropriate.
Okay, the court agrees. What I had started to mention at the last hearing, and I'm not sure if you all had an opportunity, and maybe you're gonna suggest I wait until Monday, since you're going to be submitting a new proposed stipulation regarding special master anyway, is what the court wanted to do, and I've found this in my experience with other cases, in fact, some of which involving some of the counsel. In this case, is making sure the court has a trial date rather than before you all start with your first proposed CMO from a special master, because it really allows the special master, and yes, I'm using the term special master because that's the current vocabulary on how the individual is supposed to be referred to, and the changes have not impacted this. And if you all prefer a different designation, I'm perfectly fine with it, but that's the one that's currently in use. So with regards to the trial date, is like I'm starting to say, it makes more sense to have a trial date, because then a CMO can be based off of that. It allows consistency with all the parties and your deadlines and your expectations. So that can be today if you all had already discussed it and it's already being, since you're in the process of putting in a JCCR when you want dispositive motions filed. So if you all have an anticipated date, I'll hear it today. If you tell me that you'd like me to wait to look at the proposed JCCR and add 60 days, usually is what we do from dispositive motions. Once again, I am going to have to do a carve out here because we're going to have to take into account. I've already had a plethora of variety of motions, but you know, because the 60-day from dispositive motion to trial stack, as you know, is generally when you have a few summary judgments or a single kind of summary judgment or dispositive motion, and only a few motions eliminate. This, from a management standpoint, might need something very different because of its complex nature, more similar to the other complex cases you all have done, and complex construction defect. Counsel, you're standing. Go ahead, please.
Yes, Your Honor. Michael Gayan for the state. I think just based on the way the ECC discussions have gone and the JCCR drafting, might make sense to file that, let the court look at it, and schedule a Rule 16 conference. The state's prepared to pick a date for the Rule 16 conference today, if that's most efficient, but.
What I was trying to do is trying to get you as quickly as possible, right? Your order appointing the special master so you could 2-track, right? Okay, do what you do with normal dates in the same time, get the things that you need to get done with the case management order. I'm perfectly fine doing that, but I would likely then we're gonna need some caveat in your special master order that the date's going to be set at the Rule 16 set on blank or something that clearly articulates that, so that you can get moving basically both ways, so.
I think that makes sense, and if I'm understanding the court correctly, maybe we don't hold the first special master hearing until after the Rule 16 conference.
Therein lies the challenge, because under NRCP, part of my analysis, right, is the NRCP 53 is supposed to be done within 21 days, right, from signing the order, which was one of the questions I had in the proposal I had before me. It didn't have any date triggered for a special master first hearing, but NRCP 53 says 21 days. So I didn't know if I was getting a request to modify that for good cause, or if you want a quick Rule 16 conference like next week, or what you're really requesting. So that's what I would like some insight on. And if you all think that you all want to have some conversations out in the hallway, I can tell you my other couple of questions. And if you all need to coordinate with the people remotely and out in the hallway, and you want me to call a case or two in the intervening time, I'm fine with that as well.
Do you want to ask a question? Because
Sure.
we did in our proposed stipulation,
Your 30-day.
yes, the 30-day notice. So I didn't know if that's what if the court did not want to
Well,
do that because it was outside of 21 days. I just want to make sure I understood.
the language I see on page 9 is the parties must submit a proposed case management order no later than 30 days after the special master hearing. It doesn't trigger 21 days from the court appointing a special master. That's the distinction the court was saying under Rule 53. So yes, I did see it, but those are two different timeframes. And since it doesn't say when the special master hearing has to occur, and I know you all will be prompt, but hypothetically, it could say you would decide not to do your first special master hearing for a year, and then you wouldn't have a report for 30 days. You understand what I'm saying? The way it's currently written, that's where the court had the question, which is why I triggered back to the Rule 53 issue.
Thank you, Your Honor. Michael Gayan for the state. I think maybe what makes the most sense is the parties hear the court's concerns or comments on the proposed special master appointment order, and we can discuss and potentially resubmit and address it again at the Rule 16 conference. I personally, due to the timing, would like to schedule that today. We know when the JCCR is going to be submitted. So if the court's amenable to that, we can look at calendaring and just pick a date for it. Next week seems a little quick with the holiday. And I know in conversations with Meta, they probably want to avoid next week for the Rule 16 conference.
Well, I could do July 22nd or July 24th, I'll tell you. So why don't you mull that over while I move forward and kind of mention some of the other questions, and we can walk through those quickly. Okay, so realistically, making sure all of the aspects of Rule 53, and I appreciate these get done a lot, and so sometimes certain things kind of pass along from proposed special master order to next, but I want to make sure that all the problems 53 and that they're clearly stated, right? And unless you are requesting something different, because there was some kind of ambiguous language, if you were requesting that the special master do something different other than up to discovery, right? Because there's some generic language, which I appreciate, is in certain other ones that for example, is it just through discovery, right? So subpoena issues post-discovery handled by the court. Issues only in discovery, and I am having my reports make it clear that special master does not have the authority to set dates that would modify motion eliminate dates, discovery cutoff, or dispositive motion or trial dates. Because I understand that those directly do have to come to this court first. So that needs to be clear in there. And what I'm referencing, like page 6. So it just needs to be incorporated kind of more clearly. I've had some issues in some of my other cases where not having it clearly spelled out has resulted in having some confusion about whether or not the special master can de facto change a trial date by giving the parties more time for different things, right? And so we want that clearly spelled out, that you have to seek leave from the court first. Okay. You've got the concept there?
Yes,
Thank
Your
you,
Honor.
Your Honor. Yeah, yes, we'll adjust it accordingly.
Yeah, and I understand that's oftentimes the intention. Once again, I fortunate to do a lot of complex litigations, and as I have different issues come up, I try and minimize them and have foresight not to have them come up again, or minimize as much as possible. Okay. So, with regards to, and this is an issue again, with the mediation settlement, once again, sub C, remember the court still has its rights to order a settlement conference if it deems it's appropriate, right? And I appreciate sub C is really coming from some of the old CD language, which is triggered from the statutory requirement of a pre-litigation mediation, so it needs to be tailored when it's not in the construction defect statutory concept. So this would be, during the discovery or prior to, the discovery cutoff, those type of aspects similar there. And that, nothing herein precludes the court from ordering settlement conferences, mediations, etc. And then are you all anticipating that the special master is going to have a dual role? And the reason why I'm asking that is because, under 50, some have specifically requested that when they have a judge or an experienced individual who's doing the role of the special master, and since you have, retired Judge Elizabeth Gonzalez, that they sometimes act as the mediator as well as the special master. I'm not suggesting you do or don't. I have no position on that. I just need to know if that's what you're anticipating, because if you are anticipating something like that, then it does clearly need to be stipulated to because of the conflicts issues, right? So and you don't really have to tell me the answer to that one today. It's just make sure if you are contemplating something like that. Or sometimes the parties want to specifically say, the parties reserve the right to select a joint mediator, or they have a proposal as to who might resolve if there's somebody wants X and somebody wants Y. Okay. Go ahead, counsel.
Yeah, Your Honor, Michael Gayan for the state. Quick question on that particular point. Is that something the court believes the parties need to discuss and decide now, or could we stipulate to that down the road if we get there?
What I'm trying to do is to provide you various issues that have come up in some other circumstances and things that I'll be looking for in your revised ones so that you can address them how you wish to address it. So short answer is no, it does. If you had a quick answer today and people wanted to give it to me, that's fine. If you all want to discuss it among, because I appreciate you've got colleagues both remotely and in person. If you want to discuss and then discuss among yourselves, fine. I'm just.
Thank you.
Makes more sense than sending it right back to kind of mention some of these things. Okay, I am finding sub E, and I appreciate that's some standard language. Okay, this is the refer to the presiding judge in which the consolidated actions are pending, any matter requiring assistance from the court. If you all have some clarity of what you mean there, right? Please do clarify, because that also has been brought up in some other cases. Right, because some people have viewed that may be inconsistent with the concept of the report and recommendation provision, right, with regards to objections and reports and recommendations, that somehow this would be a way to do an expedited route without going through the report and recommendation concept. Other people, once again, I don't know how you're going to view it, so I'm just saying, if you've got some things you want, you need to let this court know. Please go ahead, counsel.
I was gonna say, I think we have discussed a report and recommendation process, but I think the other problem is, I think the special master may also have, I could see theoretically the special master saying, I need some more guidance from the court on this matter. So I think that's really all that was trying to open up.
Right, which goes to my next point. If that was where you were going, some of these stipulations and proposed orders have specifically said that there can be ex parte communication between the special master and the district court judge on fill in the blank.
Okay.
Right? So that we address that issue, but then people don't point to this court and say, well, this paragraph says we can do it this way. And then the court gets an OST. The other side says, no, this really has to be handled by the special master. Once again, just proactively trying to address certain things so we can get you taken care of. Okay. When we get to the report and recommendation aspect, and this issue is currently happening, and some of you might have just gotten an order on this yesterday, is and this may be addressed better in a CMO versus the stipulation. I'm not taking a position where it needs to be. I'm just going to give you a heads up, is that when this court is getting proposed report and recommendations, it needs to be clear what the report and recommendation. I appreciate that different people have different experience in handling a variety of different roles, and this is nothing negative to anybody, but there also has to be clear indices, references to documents, etc. And without going into too many details, I've recently found, including a more recent one, about 900 plus pages just filed with nothing to kind of give the court a heads up of what it should be. And that's, once again, not a negative to anybody. It's just, we're trying to make that more clear. So whether you're addressing that in a CMO, etc., please do take care of a clear pattern on how you want the report and recommendations done. Special master.
Your Honor,
Sorry, go ahead.
if I may, yeah. I just
And
wanna go
please
back
don't
and say-
mention, you do know the other case I'm referring
I
to,
do,
and we're
I
not gonna
understand.
mention names, and like I said, there's nothing negative in it, it's just we wanna make sure everybody gets a wonderfully clear opportunity to have everything taken care of.
This entire process is to assist Your Honor, and we certainly want to make it as easy as possible. That's on you and on the special master. The comments I was going to make, without getting into too much detail, we did share this proposed order with Judge Gonzalez to get her thoughts. She did suggest some language on the report and recommendation submission process. We used to have some more detailed language on that in this stipulation. It got a little complicated with Meta's sealing concerns and how we would do that on the exact record issues that you're talking about. So if things do come up on an objection, how do we make sure they're sealed properly? And it got so complicated that the parties agreed it was best to consult with Judge Gonzalez first and put that in a proposed CMO instead of trying to do it in a vacuum without her involvement. So we have tried to work through and think through some of those issues, but are kind of putting that off for the special master hearing.
And that makes practical sense, but it's not really efficient, I thought, from you all's needs for me to then see a proposed CMO have you come right back in and say, look, here's some of the issues. Seem to me more efficient and effective to kind of just outline some of the things that I've learned from experience, that, and then you all can make note of it and determine whether it should be A, in your proposed stipulation, B, in a CMO, but just make sure it gets taken care of. That make practical sense?
Yes, Your
Lovely
Honor.
to see
Thank
you all, but I thought that kind of was a more efficient way of handling it, so, okay. NRCP 53 issue, paragraph 8 on page 9. Whatever fee you want to pay and how you want to do it is fine, except for it does need to have some language that if there's any change in that fee structure, right, it has to be approved by the court. Unless you all want it to be that you can stipulate to an increased fee. It just needs, once again, issue came up in another case, right, when there was a kind of change in rates, and who decides that, how that gets dealt with, so just address it how you wish. I don't have a preference, it's just an issue. And then, like I said, the last one was that 53 does specifically require that the special master hearing has to be in 21 days, right? After the appointment, and so then we can get that part taken care of. Okay, those were the court's just general, I'll call them guidance questions / statements. Is there, oh, there's one other one. There's one other one on page 9. On page 9, some language was deleted, which the court had interlineated on a different special master. So if you go to your top line on page 9, it says agreed. I'm just gonna read the partial sentence. Agreed by the parties or ordered by the special master or court. And if you would refer to another appointment, I've interlineated that in at least one other, and so might as well. Is there any objection to adding that language in there?
No, Your Honor.
Oh, Your Honor.
Okay, so it's just, that's probably the quickest, easiest thing. That's all from the court's standpoint. Is there anything that you all would like to discuss with regards to the stipulation proposed order appointing a special master, other than you're gonna ask me when I need this back by, but. And then you're going to tell me suggested dates for a Rule 16 conference and that structure, but go ahead, please.
Your Honor, Michael Gayan for the state. No questions from me on the court's comments. Those are very helpful. We'll work with Meta's counsel and prepare a revised submission. Happy to have a deadline to do that. In terms of the Rule 16 conference, I think I haven't checked my notes, but nobody's come and tapped me on the shoulder and said either of the dates the court mentioned, that July 22nd or 24th are an issue. So I think we'll take either date. And then I don't want to hijack this conversation, but the parties did have a quick question on the proposed findings of fact and conclusions of law that we discussed last week. So I don't want to lose that before we leave.
Okay, so let's finish up this, okay? And then put a placeholder in that part. Go ahead, counsel for Meta.
Yes, we would like to schedule the Rule 16 conference. Let me back up. I agree with Mr. Gayan. Your comments have been very helpful. We will revise this and get this back to you. We would like to schedule the Rule 16 conference. I'm going to defer a little to Mr. Sneed in terms of his schedule. I would ask one question, Your Honor. Do you do Rule 16 conferences? They're in the morning, correct?
We generally do them at 10:30 on Tuesdays. That's the reason why I said the 22nd. Realistically, that's when I would normally have set this. The reason why I was offering you the 24th is because I'm trying to be appreciative that you have a lot of people from all around the country. And so if you needed something special, then my clerks could put in a new setting, but normally it is 10:30 on Tuesdays.
That would work for me on the 22nd, but Mr.
And
Sneed.
and that would work for me as well. I actually would prefer the Tuesday at 10:30 if at all possible. So that would be wonderful, Your Honor, in terms of the timing for the Rule 16 conference.
Okay, anybody else need to be heard or want to be heard? Okay. So that means we'll do, so by request, specific request of the parties, since I don't yet have a JCCR, the court's gonna find good cause to modify the NRCP provisions of scheduling the Rule 16 conference because the court A has deemed it complex, and for the other good cause mentioned by the parties, including the fact that we've got people from all across the country, is going to set this on July 22nd at 10:30. And that is, obviously, I do need to see the JCCR before then. Obviously, I'd have to vacate that date if I don't have a JCCR. I have no reason to think that you wouldn't comply with the rules and give me a JCCR, but okay. Does that take care of everyone's needs for what was set for today with regards to status and discussing your special master and getting your JCCR? And by the way, in your JCCR, you all might propose some trial dates, right? Okay, take into account. And I'll just mention one thing real quickly here before I should have said this before I closed on that part, is with regards to, since you're going to be advanced looking individuals, remember in CD cases, oftentimes dispositive motions and motions limine are done in the first day of trial because parties want to maximize, well, for a variety of reasons, including I've been informed that parties want to maximize their opportunities for resolution. And so they don't want to, they're okay with preparing them, but actually not to have them heard, and they prefer them to be that. And sometimes it's changed, okay? Other cases, parties like to have them heard as they come up. I will tell you, at least for motions limine, given the, if you're thinking you're going to be doing triple digit motions limine, okay, or high double digit ones, it's not going to be efficient to do those at varied times. It's going to be more efficient and effective to set a particular date, right, and have them heard and do deadlines. So if you want to anticipate that, once again, you all are gonna have a better idea of what you're thinking now, realizing it's far down the road, but, or if you want things staggered, you've got to give me, please, a heads up, just so that we get you taken care of. And that was just my heads up. It sometimes happens in these complex litigations. People want things staggered. Maybe they want a round of certain types of dispositive motions earlier on, and then another round, you know, they want to self-impose different deadlines. Remember, you're not limited specifically to some of those deadlines. You can add new things. Okay. So go ahead, counsel. You had a question or a statement?
Yes, Your Honor, Michael Gayan for the state. I was just going to comment that we've worked through some of these issues with your downstairs neighbor in 15B on the SNAP case. And I believe we've had similar discussions about needing a little bit more time for the various briefing after the discovery cutoff. So we're still working through the JCCR. We're waiting for Meta's latest round of comments, and we'll certainly address those types of concerns and make sure it's a reasonable schedule based on the nature of the case.
And I'll say, Your Honor, yes, we are in the process of having those discussions, and we do anticipate, as you suggest, needing some additional time, given the complexity of this case, leading out from discovery before a trial date, given the various types of briefing that we do anticipate that would need to be addressed after discovery. So I know you mentioned earlier, there's the default time frame. We certainly think that we might need additional time. And Mr. Gayan is right. We are getting comments back on the JCCR, such that we'd be able to file that on Monday as required under the rule, and we will be prepared to do so.
Okay, is Monday doable? Because I hadn't yet heard somebody request extra time, which I was actually,
Your Honor, Michael Gaines.
why I scheduled today was to make sure you all had enough time, but if you don't, gotta let me know.
Monday doable for the JCCR or
Yeah, for the
the?
JCCR.
Yes, as far as I'm aware. I don't know what changes we're going to get back from Meta, but I anticipate we're on track.
Would anticipate we're on track. However, Your Honor, you are bringing up some things that we have not fully discussed in terms of scheduling for motions and limine and things like that, that we were not addressing in the JCCR because they're not really covered.
You don't have to.
Right,
But
and so I just want- I wanted to-
realize most, and you all know this is sophisticated, complex litigators, right? The more you put in your JCCR, the more opportunity you have to get that incorporated into a trial order so that you can schedule what you need to schedule, fully realizing that life happens, right? Okay. My cases, no one really anticipated we'd have 200 plus depositions in lieu of live testimony. So we then had to find a way to get those all heard, right? And objections taken care of. So we take care of it. It's just the more you do up front gives you your better scheduling to the extent that you can anticipate things. So are you asking for more time?
I was asking if you wanted more information in the JCCR, because if you did, yes, we will need more time. So, but otherwise, I think we're on track to be able to deliver that. on
Court is not
Your Honor, my
required.
preference would be to submit the JCCR on time on Monday, and the parties have 3 weeks thereafter to talk through these things before the Rule
That's
16 conference, and we can address them with the court.
The court's not requiring anything more in a JCCR, realizing that you have some counsel that it. Pro hoc vice counsel, I give the courtesy to mention that these are not. The only things that sometimes people do other things and add in different things, which you probably already told them anyway, but sometimes people have a question about whether the court's okay with it. As you know, this court's okay with it. If it's legal, ethical, it makes practical sense, you generally okay with it, and not objective to, but the other side, I'm generally okay with it, so.
Thank you, Your Honor.
Okay, so with that regard, then you all had a quick question, and the reason why I'm gonna use the term quick, because everyone else is patiently waiting for their 8:30, right-ish time frame. I need to take care of them as well. So what is this new issue on the proposed findings?
It's just a mechanics issue, Your Honor. We intend to file a proposed findings of fact and conclusions of law. We didn't know if you wanted also a Word document emailed to you, or if there were any concerns in that regard.
Yeah, that was the question, Your Honor. I think both sides, due to the gravity of the issues or whatever, we would want to file and serve so they're in the record, what we proposed. But in my experience with this sort of situation, the courts often like a Word version
Yes, please.
to work with. Okay, thank you. So we'll email that as well.
Yes,
Thank
please. And based on the way that you're intending on doing it, is it a correct assumption that you aren't going to be circulating it to each other before you're submitting it to the court?
That's correct, Your Honor.
That is correct.
Because my next, if you were circulating, then I would be saying, please redline, right? But since you're not, and I'm not requiring that you do, then yes, please send to my JEA it in Word and CC the other side that you are doing so, please.
Yes, Your Honor.
Okay. And please, and I already, well, I know I don't have to say this, but I'm gonna say this one anyway, because I presume you're going to cite to things in the record and not just say see record.
Yes,
It would
C
be
generally
mostly-
is useless in my opinion. So
See,
Yes,
at
Your
the
Honor.
hearing and exhibits.
The court handles a lot of cases, so sometimes just mentions things because it's easier and it's more efficient and to actually have the actual citations right in there. Not in any way implying that people wouldn't do so. I've just been doing this a long time and so. I kind of-
Sounds like one of those warnings on the ladder type of thing that's prompted by some weird experience.
I have had the opportunity to have a wide variety of cases, and I do appreciate each and every one of them. Anything else I can do for you, or say we're taken care of and have a great rest of your
No,
day?
Your Honor, thank you for
Thank
your
you.
time as
Thank you
always.
for
Hey,
your
we-
Thank you very
okay,
much.
thanks.
Thank
And
you.
have a
Thank you, Your
happy
Honor.
holiday if I don't see you on another case next week.
Thank you, Your Honor.
Thank
Appreciate
you.
it.
Okay, appreciate it.